to the trial of Alex Murdaugh, Endgame. It has been a very long process here, more than 4 years since this all started, and now we're finally at a point where we're in the line to go ahead and get that verdict. I'm Andrew Davis from WSAV out of Savannah and Hilton Head. Thank you for joining our simulcast with WCBD.
And I'm Riley Benson out of Charleston County, Berkeley County, Dorchester County for WCBD in Charleston. Andrew, let's talk about it. We're at the midway point of week 6. We heard 81 witnesses, 67 for the state, some of those repeats, 14 for the defense. You estimate 175 hours of testimony, more than 1,000 pieces of evidence, and we still have some time to go. The light
We're still not done yet.
We're not done yet. The light's at the end of the tunnel, but certainly this has been a long trial here in Walterboro.
Absolutely. And we thought we were going to get to the defense closing arguments. We'll talk about that in a minute, but instead it was all about the prosecution today. Creighton Waters taking more than 3 hours to lay out his case one more time.
Well, we knew this was going to be a lengthy process, right? They both asked for, well, the defense asked for a time limit on this. They said no, so here we are 3 hours, 15 minutes later. You know, the state really walking through a number of factors and points, kind of hitting on things that we've heard now for 5.5 weeks.
Absolutely. We wanted to start exactly with what he started with. Creighton Waters' opening arguments, those first moments that he presented to the jury today.
On June 7th, 2021, at the Moselle property in Colleton County, Maggie Murdaugh and Paul Murdaugh were brutally and maliciously murdered at the kennels by Alex Murdaugh. Paul, as you know, suffered 2 shotgun blasts. Maggie suffered 5 blackout rifle wounds. And after an exhaustive investigation, there is only one person who had the motive, who had the means, who had the opportunity to commit these crimes, and also whose guilty conduct after these crimes betrays him. The defendant was the one person who was living a lie. The defendant is the person on which a storm was descending, and the defendant is a person where his own storm would actually mean consequences for Maggie and Paul, and consequences for those who trusted him. And that person is the defendant, Richard Alexander Murdaugh.
You know, Andrew, we talk about this 3 hours and 15 minutes. We were expecting the defense to do theirs today as well, their closing argument. We didn't get there. We broke at about 4:30 just before the show. So, you know, obviously the defense is going to go tomorrow morning. Jim Griffin is expected to make that argument, but certainly we did not expect that to happen on Thursday morning.
I don't think Jim Griffin did either. When you looked at his face, he was deciding, he's saying, if I start at 5 o'clock, I'm going to go till at least 7 or after, and that's when they decided to go ahead and push it till tomorrow. I think that's best case scenario for the defense. But you know what? I'm not a lawyer. Luckily, we have a couple with us.
We do have 2 with us. Let's start with Joe McCullough. He is a South Carolina native out of Columbia, longtime attorney. And Joe, kind of give us a background. You've been sitting with Andrew and I for the last 5.5 weeks.
Well, I represent Connor Cook in the boat accident, one of the people injured there. So I have a lawsuit against Alex Murdaugh and against Parker's Convenience Stores. So I'm here as much to protect those interests as out of some degree of curiosity. It's a fascinating trial. It's hadn't expected to be here 6 weeks, and teach at the law school. So you know, I'm into a lot of things, and this is just one more thing, but it's an important thing.
Yeah, and we're also here with Sean Kent out of Clarendon County. Sean, you've done a lot of these type of cases before. You've worked with basically everybody in that courtroom so far, haven't you?
Everybody in that room, I think I've tried a case with or against,
yeah. So tell me, let's just start with this. You talked about Creighton's testimony today, his closing argument. What was the first thing that comes to your mind when we're finished with that?
It's funny you called it testimony because I thought it was too long. I thought it was entirely too long. Jury's been sitting there for 6 weeks. You guys have gone through all the evidence they've listened to. Juries have small attentions just like anybody. And if you're going to try to get a jury to pay attention to you for 3.5 hours, you better be bombastic, you better be interesting, you better be loud, you better be theatrical. And I saw none of that. I just saw pure boredom, if I'm being honest.
Yeah, especially by the end of that one, definitely.
And Joe, let's kind of break down to some of the things they talked about today. You know, you and I, and you had brought up the point that they kind of pivoted from these financial crimes to more of the family annihilator. That was something that we talked about in the courtroom. Your thoughts on that?
Well, I think that's a problem for the prosecution. They started in their opening argument and said the motive here is the financial crimes created a situation. All was going to be revealed. Everything was going to unravel on June the 10th in a meeting or in a court hearing, and that was the motive. And somehow now, today, we strayed into this pivot to now he's a family annihilator, a person who snaps and kills his family, slaughters them. And I think the jury may feel a little bit betrayed. The only thing going for them on that score is that was 6 weeks ago. And this is a tired jury. Jury fatigue set in weeks ago, and I don't think the argument today really lessened that fatigue.
That's what's interesting is even we were looking at bites today to try to get those sound bites from the trial. I went back to day 6 or 7 and had no idea who was there because it's been so long, and I know they were in the same thing. No notes out there. That's been a big question for a lot of people. You know, in a trial this long, what does that mean for the jury, and how does it hurt or help either side?
It hurts both sides. I mean, that's a long trial. 6 weeks. You can't rely on a memory on a 6-week trial. And either side would have had an easy avenue, an opening statement to say, hey guys, if y'all want notes, ask the judge, and the judge would have given them notes. I think that goes to the inexperience of the Attorney General's office in trying murder cases. I just don't think they've tried a lot of them, to be perfectly honest. But notes, to me, when you have the details like the prosecution has, they need the notes. And so it's a big deal that they didn't ask for.
And maybe a question for either one of you. I mean, we're looking at 1,000 pieces of evidence. When this jury does get to the point of going to the deliberation room, how long of a process is that for them to go back through, you know, maybe any of this evidence?
The judge will tell them that all of the evidence in this case is going to come to the room with you, and you are free to pick it up, see it, and so forth. But I thought it odd today, taking a jury for a closing argument in the middle of the day or the late afternoon is the worst time for lawyers, because the jury's tired. They had a little field trip today, but they're still tired. And so the lack of drama, I was fascinated that the state thought it important to introduce 6 guns that ultimately had nothing to do with this case, perhaps. But they didn't wave them around. There was not that dramatic moment where they pulled out that scary AR that may have had nothing to do with this crime. But it's in evidence for some reason, and I thought it was a demonstrative vehicle, but it wasn't used.
Well, that's what's interesting. We were talking about the visuals too. You're talking about a working class jury out of Colleton County. They absolutely were more intent on watching anything that had to be visual, some sort of videos, or if you put something in front of them. You know, I feel like maybe from the defense side they lacked some of that, and that could have drawn them in. I'm sorry, from the prosecution side could have drawn them in.
Well, Joe said it the best. I don't know how all these guns are in evidence, but somehow these guns that have nothing to do with the crime are in evidence. But if they're in, I'd be flashing them all over the jury. If I were y'all, you have a trouble finding that soundbite moment, and I guarantee if you've gone and looked at that entire closing, there's not that one point in time, like the point when Mr. Harpootlian pointed the gun, we have that moment. You don't have that moment from a closing argument. And if you're doing a closing argument, there's got to be that moment. There's got to be that aha moment when every juror in the back goes back and they say, wow.
We got close at the end.
We did.
When he talked about, they showed the video and the kennel. I mean, no, this was the first interview when the police first arrived. But that was well concealed in the argument.
Well, in the rap, too, talking about the fact that Maggie and Paul deserved a voice and the juror was the voice in that case. I thought that was a nice closing. No, in this case, am I wrong with that?
I think it's a great closing. It's completely impermissible and probably should have been objected to and shouldn't have been gone in front of the jury. It's a great point, but there's an unwritten rule. It's only objectionable it's only objectionable if somebody objects. Nobody objected. But that was a strong move by Creighton Waters. It was strong to come in. It was a powerful way to end. It's 100% objectionable and should have never gotten in front of that jury.
And you mentioned, Riley, I think you mentioned that there are 1,000 pieces of evidence. This was the state's opportunity to say, there are 1,000 pieces of evidence, but you don't win these trials, and your decision can't be based on weight and tonnage and numbers. So let me show you the pieces of evidence that are important, and you put them up on the bar in front of them, and you bang away on that, right? You bang away, and you say, when you get back there, don't worry about this stuff. Here's what you need to look at.
Yeah, absolutely. Well, we've got a lot more on that, including what the defense will do tomorrow. We're going to talk to you guys about that, as well as Judge Newman's performance so far. He seems to be a celebrity on social media, but should he be the way he's acted in the courtroom? We're going to have much more of that.
We're certainly going to talk about the jury insight, too. A lot of things going on there with the jury, Andrew, but we'll talk about it when we come back as well.
Absolutely. Welcome to the trial of Alex Murdaugh, Endgame. We'll be right back.
Walterboro, South Carolina, where Andrew Davis, WSAV, and myself are breaking down the Alex Murdaugh double murder trial as we are starting to near the end. But Andrew, you know, we talked about one thing. Us two, we were the only ones to really report and say that Alex Murdaugh would be taking a stand. We said that about a week before the trial. We had it the day before. No one really thought that Alex Murdaugh would actually take the stand as part of his defense. Certainly 14 hours of testimony, him on the stand both Thursday and Friday of last week. Big moments in this trial.
Absolutely, and he did a lot for his own case with the tears, with the incredible sound that he had. The one point I think that we want to point out, though, is when he talked about his own paranoia about why he lied.
When I got to thinking in that paranoid way, that normally, as I said, I mean, I could take a deep breath and make it go away. I never had a situation where it lasted more than a matter of seconds. That night, after all those things had happened, it didn't go away in a matter of seconds. And I decided to lie.
Well, Sean, we'll start with you on this one. I mean, Alec really made a lot of impact early on when his own lawyers were talking to him. You saw the tears, you saw the incredible emotion, but then he talks about paranoia and the fact that he got paranoid all the time, but in this case it didn't go away. How are we supposed to believe something else?
I thought that fell flat, if I'm being very honest. I'm with you guys. I thought he had to testify. I thought he needed to testify. I joked on social media he had to go with the Eminem 8 Mile defense. He had to tell these people everything about himself. He's like, prosecutor, tell me something you don't know about me. I thought Jim Griffin was amazing on those first couple of questions, but it's easy to do direct. I thought the pill fell flat, but you had to offer something. And I thought, actually, as much as I've given the prosecutor a hard time, I think the way that they hammered away at the lies that he's done, how can you believe this person now? I thought it was very effective. I thought it was much more effective than the financial motive. I think the line, you can't believe him, he's an admitted liar. I can't believe this pill thing. That's what I thought of his testimony.
Good point. You know, and Joe, you've obviously been sitting in the courtroom for most of this trial. You hear the state continue to pound away at the fact that Alex Murdaugh has looked people in the eyes and lied to them. He's looked family members, friends, clients, colleagues. You continue to hear about how Alex Murdaugh was lying up until last week in this trial. I mean, the effectiveness of that from the state, your thoughts in hearing that in court?
Well, I mean, they've convicted him of being a thief and a liar 3 weeks ago, 4 weeks ago. I think to some extent that plays into the jury fatigue stuff, but the, that's effective. That's purposeful with the jury. It also begins to border on propensity evidence, which is a technical thing that may prove to be an issue if an appeal is necessary here. But, to go back to the paranoia stuff, I really thought that he would have been better served by saying, I was scared. Paranoia, to me, when he crawled on the psychiatrist's couch in front of the jury, I thought it was odd. It seemed off-putting to me, and also it implants or suggests to the jury that maybe I'm mentally ill. The technical term paranoia, this is Walterboro, South Carolina. I was scared. Would work so much better, it seems to me.
Well, for both you guys too, the idea of ego comes into play. Does that come in when you're talking about Alex Murdaugh saying, I know I can convince this jury of what I'm saying if you put me on the stand?
100%. I wasn't a part of the meetings. I don't know what the conversation was, but I can promise you he told his lawyers he wanted to take the stand.
Lawyers and doctors, terrible clients.
Worst clients you can possibly have. So I guarantee you said, I want to take the stand, I want to look him in the eyes, and I want to tell him my story.
And so then does it make a difference? Did it make a difference in this case, the emotion that he showed, do you think, for the jurors?
Oh, yeah. I mean, it definitely did. I don't know how much, but it definitely did. I think in this unique case, he had to take the stand. And I think that's because, personally, I believe it was an error letting in all the financial information. The second that financial information came in, which it shouldn't have, and I'll go to grave saying that, it should not have come in, but the second it came in, he was in such a corner, he had to get on that stand, is my belief.
Well, he was in the kennel corner,
in the kennel corner as well.
And that was a biggie because it was clearly his voice. Everybody in the courtroom identified his voice as on there. It was part of their timeline. It's still a critical component of the timeline case that was made this afternoon. But there was only one person alive who could explain why his voice was on that kennel tape. He was the guy. I don't know how effectively that was dealt with. We'll see.
You know, obviously, we've talked a little bit about the overall performance, but, you know, I think some of us took away Thursday that Alec held a very strong, you know, in cross-examination, but Friday came back and maybe, you know, got beat up a little bit by the state. So I don't, you know, either one of you want to chime in on how, you know, effective this was and what points really will stick with the jury when they take this to the deliberation room.
Well, I'll give you the short answer and then flip it to Sean, but he was on the stand for a good while with being led by his own lawyer in the direct presentation, and he did very well. When he was turned over to the prosecution, they meandered. There were a lot of questions. They were tedious, and perhaps that was purposeful. It's kind of like a fisherman letting the fish run to tire them out. Then you reel them in, and they're easier to reel in, and they reeled him in, and the prosecution ended on a high note when they got him to adopt that when did you lie business as a paranoia about SLED, and then they showed that just wasn't true. Another lie.
You have a self-professed liar on the stand, and you're giving him open-ended questions. Thinking backwards, Creighton's closing argument, when he mentioned this man is a lawyer, this man is a prosecutor, this is what he does, I thought that was so powerful. That should have been hit with a cross-examination. It's like, you are a lawyer. You know how to convince people. You are a liar. And then say that to the jury. I think that hits a little bit better than those open-ended generic questions.
So we heard from prosecution today. We're going to hear from defense tomorrow. Today, we'll tell you exactly what the defense should say, according to some of our experts right here, or could say on this one, as well as everything else that's going on in the courtroom as you're watching your special simulcast of the trial of Alex Murdaugh, Endgame, on WSAV and WCBD.
Stick with us. We'll be right back.
And for some reason, I thought it was something that I needed to do for Paul to clean it up. Felt like it was the right thing to do. I felt like I owed him, and I started cleaning. It's the hardest thing I've ever been through in my life.
That was John Marvin Murdaugh, Alex Murdaugh's brother, talking about cleaning up Paul's remains and even his brains in the kennel itself. It may have been the moment, other than Alec on the stand, that everybody's remembering.
Certainly, you know, the last witness for the defense, and the last thing he said was he made a promise to Paul that he would find who killed Paul and Maggie, and said he has not fulfilled that promise yet. Certainly powerful testimony in the courtroom. Your last witness for the defense. Either one of you want to chime in on how that played out for the jury?
Well, I think it played out in a fashion of humanizing the Murdaugh family, reducing the demonizing that frankly has been going on for 6 weeks. But what occurred to me is this jury was essentially kidnapped by the system, conscripted into this trial, has been exposed to the worst horror movie that any of us could see, and now they're being asked to make a judgment. I mean, that's overwhelming to me, and we do nothing for the jury after that. We send them home and say, don't worry about the PTSD. But I think for the jury, in consideration of the case, John Marvin helped the family be human and helped his brother, because he was there to speak for his brother.
Well, and that thing now, we've only got about 2 minutes left in our show here, so we're not going to go as long as Creighton Waters did today by any means. But maybe, Sean, give me a sense of what the defense needs to do tomorrow, maybe one point that you can point out for Jim Griffin.
They've got to be entertaining. Jim Griffin is going to do the closing for the defense. He says he's going to go 2 hours. I think that's too long. I think he needs to grab him by the attention, because right after him is going to be John Metters. I always refer to him as the prosecutor from My Cousin Vinny. So he's going to be theatrical, and he's going to identical everybody. So John's got to take that jury by the horns, and he's got to look at him. He's got to tell a story.
Joe, what do you think? Quick one.
I've just watched My Cousin Vinny. Yep.
Am I wrong?
There's going to be a lot of that. There's going to be a lot of voice raising, and I think that Griffin has to do what he did when he presented Alex Murdaugh. He came out with a gun. He surprised people in the courtroom with his energy, and the defense has got to be energized. They've got to show
Metters is going to be
and they've got to answer that one big question: why should we believe him now?
Absolutely.
And certainly, you think they're going to try to paint him as the loving father, loving husband too, right?
Completely.
Yeah.
But Joe's got the right question. It doesn't matter if they don't believe him. It's like loving father snap.
Yeah.
And so they got to say, why is this a loving father, and why do we believe him? And that's where you got to go with the forensics and the evidence, and says he may be loving, but he couldn't have done it because science didn't let him do it.
Absolutely. Well, we're going to see tomorrow morning starting at 9:30. Joe, we're going to have to save that for tomorrow. We'll be back at 5:30 tomorrow, and right after the actual charging of the jury, right here on the trial of Alex Murdaugh, the endgame for Riley Benson, for Sean Kent, for Joe McCullough, and myself, Andrew Davis from WSAV. Thank you so much for joining us on WCBD or on WSAV tonight. And we'll be back with you with much more coverage the entire time of the Alex Murdaugh trial and verdict.